In previous videos, I've talked about doing a trust instead of a will, or a trust instead of, or even a will is better than no will at all, but why you'd want a trust instead of a will. And again, just to go over those, there's privacy concerns. You control how your property is transferred without having it be in a public forum. You save on certain costs and fees if you have to probate a will, or if you die intestate and your estate must be probated in court. So these are some of the advantages. So what exactly is a trust? Well, a trust is a legal document in which the grantor, the person who has the property, puts it all in the name of the trust. For example, if your name is John Smith, then you can title the trust Living Trust of John Smith. You, as the grantor, then put your property in the trust. The trust is a legal document that you create, but then it's just a legal document until you put assets in the name of the trust. Once you do that, now the trust has assets. Typically, not only are you the grantor, but usually you are the trustee of the trust, the person who handles the assets of the trust, decides whether to sell them, what to invest in them, etc., makes all the decisions just like you did when you didn't have a trust. When it's owned by John Smith, you just make all the decisions. Well, if it's the living trust of John Smith, you're still making all the decisions. But now the owner is the trust and you are the trustee. Now, these trusts are usually living trusts, which means that at any time as a trustee, you can decide to close the trust and then transfer the property back into your individual name. But if you don't and you decide to keep it in the trust, since the trust document will then say what will happen to this property when I pass away, or if I become incapacitated, who will replace me as a trustee to administer these assets. But again, when you pass away, the trust then determines who this property goes to, similar to a will, but without having to go through the probate process, meaning not having to go to court, not having to pay certain fees and costs, and not having to have the will public that anybody can see. It is private. Now, generally speaking, what a trust is not for is it cannot somehow avoid general taxes you would be paying. So if you're single man, single woman, and you create a trust because you have a lot of assets, by creating the trust, you are not suddenly saying, okay, all of this is tax-free. I can transfer it without worrying about taxes. That is not the case. When you pass away, your property is subject to gift or inheritance taxes. And in California, there are no state inheritance taxes. There are only federal inheritance taxes. Whether you have to pay them or not depends upon the inheritance tax and certain exemptions. Just putting in trust will not, in and of itself, avoid taxation. Again, there are certain situations where it might matter. For example, if you're married and you have a large amount of assets, over 25 million as of 2023, then it can make a difference, and you're creating the trust in a way to avoid that tax, avoid over the lifetime of you and your spouse, avoiding paying taxes on property that's transferred. But that is something for you to talk about with a legal professional to understand better. Generally speaking, though, a trust is for you to be able to transfer your property to avoid probate fees and to keep it private, so it's not put out in the public, because if it's probated, it must be filed, the will must be filed in a court. So therefore, once it's filed in court, it now becomes a public document. People would research your name, find out when you passed away. If you opened a probate, look at your will. But if you have a trust that is not probated in court, under normal circumstances, under typical circumstances, your transaction will be private.